Hello, my name's Emma Leavesley and I'm a family solicitor at Parfitt Cresswell. I'm going to talk to you about arrangements for children upon divorce and separation. One of the first concerns that many clients have is how they would come to an agreement with their spouse or former partner for the arrangements for their children. The position in law is that the parents are encouraged to try and reach an agreement on the arrangements without the need for the court's intervention. This is known as the no-order principle, and it's hoped that parents can be flexible and amicable in making arrangements for resident and contact. Sadly, this is not always possible, and the court is there to assist should it be required. The relevant legislation is the Children Act 1989, and in particular Section 8 of that Act. This section of the Act allows parents to make applications to the court for a residence order, a contact order, prohibited steps order, specific issue order and a parental responsibility order. A residence order is an order made by the court which states which parent the children will primarily reside with. If the children are spending time with both parents, then the court can make a shared residence order, even if there is not a 50-50 split of the time. A contact order is an order which defines the contact that the non-resident parent will have. A prohibited steps order is an order made by the court which expressly prevents one or both of the parents from doing something, such as removing the child from England and Wales. A specific issue order is made where the court is asked to make a decision on something specific, such as what a child's name should be or which school they should attend. A parental responsibility order gives the father of a child parental responsibility when he is not married to the mother or he is named on the birth certificate but the birth was registered prior to the 1st of December 2003. When an application is made to the court, the primary concern of the court is to investigate what arrangements are in the best interest of the child or children concerned. In order to investigate this, the court looks at the welfare checklist, which is outlined by Section 1 of the Children Act. The welfare checklist has 7 points which the court should consider when investigating the best interests of a child. These points are as follows. Number 1, the ascertainable wishes and feelings of the child concerned in light of his age and understanding. Number 2, his physical, emotional and/or education needs. Number 3, the likely effect on him of any change in his circumstances. Number 4, his age, sex, backgrounds and any characteristics of him which the court considers relevant. Number 5, any harm which he has suffered or is at risk of suffering. Number 6, how capable each of his parents and any other person in relation to whom the court considers the questions to be relevant is of meeting his needs. And number 7, the range of powers available to the court under this section of the Act. As you can appreciate, there's a lot that the court needs to consider, which is why these proceedings can be lengthy and expensive. The court will usually instruct an organisation called CAFCAS to assist them in their investigations. CAFCAS stands for the Children and Family Court Advisory and Support Service, and they are an independent body whose role is to firstly promote the welfare of the children as well as safeguarding them, secondly completing the investigations and giving advice to the family court, thirdly making provision for children to be represented in case where this is required, and finally providing information, advice and support to children and families. CAFCAS will complete investigations and they will then make a recommendation to the court. It's highly likely that the court will follow the recommendations unless there is clear evidence as to why they should not. When an order is made by the court, it will now have a warning notice attached to it. There was a change in law in December 2008 which meant that every Children Act order has this warning notice attached. This warning is addressed to both parties and makes it clear that if the court order is not complied with, then the court can enforce the order. If a party breaches the order, then an application is made to enforce it for contact to resume immediately. The court will then consider the breach and can punish the party as it is treated as a contempt of court. Punishments range from a fine, unpaid community work, suspended prison sentences and even in severe cases, full prison sentences. The government has put forward proposals to change the law relating to the role that each parent takes in a child's life. The government has held a public consultation and is currently reviewing the law. The government would like to reinforce the principle that both parents should continue to play a role in their child's care and upbringing following their separation. It wants to strengthen enforcement actions available to deal with breaches of these court-ordered arrangements. The government also hopes to provide much more information to parents other than to try and exhaust all the dispute resolution options with the court being the last resort. It's also proposed that there be an online system which will set up as the first stage of dealing with the disputes and will provide diagnosis and help for separating couples. The government also wants to promote mediation, information and assessment meetings, which parents are required to attend before making any application to the court. At the moment, it's easy for the parents to find a reason not to attend a MIAM, but it is proposed the court will order the parents to go back to mediation before their application is taken any further. If the changes are made, then the courts will no longer look to contact and residence orders. They will be replaced with child arrangement orders. It's hoped that this will stop the parents believing that there are winners and losers in these cases and will promote more of a shared care arrangement. With enforcement, it's proposed that one of the parent breaches the court order within 12 months of the order made, then the case will be brought back to the court as soon as possible, and ideally before the judge who made the order. The aim is to have the arrangements put back into place within a matter of weeks rather than months. There's also going to look at further punishments, including withholding passports and driving licence, as well as curfew orders. The government really wants to make it clear that the court can switch residence from one parent to another if there is a persistent refusal of contact as well. The family team at Parfitt Cresswell are here if you need any advice or would like any assistance in trying to sort out the arrangements for your children. If you need any further information, please do not hesitate to contact us either by email at family@parfittcresswell.com or call us on 01753 271 640.